Good morning and welcome to Time to Talk Tuesday with myself, Claire Keeley from Claire Keeley, Funeral Celebrant. And today I've got special guest Ruth Pannell. Good morning, Ruth.
Morning, Claire. Thanks for having
Morning.
me.
Oh, it's lovely to have you here. So for those of you, you've obviously seen the little clips and videos I've done. Ruth you're trained as a solicitor, aren't you?
I am, yes.
Yeah, you are a solicitor and you are from Isla Law, which is your own practice, isn't it? It's a
Yeah,
family
I set
practice,
my
I
own
believe.
up about 3 years ago. Yeah,
Oh, okay. So you practice first and then set up on your own.
that's right. Yeah.
Oh, brilliant. Okay, so Ruth's going to talk to us today about writing wills and life and legacy planning. And it's something that I'm quite passionate about, that I know I've got to sort out. And I think it's something that we put off because, as we've discovered from death conversations and things, people don't like to talk about it. And I know a common thought is, well, I haven't got anything to leave, and I always joke, well, you won't get any money from me because I haven't got any, but there's still things that need to be sorted out.
Yeah.
So obviously we're live. If you've got questions, I have got my Facebook on my page on my phone. Sorry, I've got my phone running as well. So if you want to, just got to make sure that that's not sound, otherwise you'll have two of me and two of Ruth, which will be very confusing. But if you've got any questions, if you pop them in, Ruth will answer them if she can. Oh, Jenny's watching. Remember Jenny from our lovely Jenny's watching, and my friend Rick. Morning, Ricky. You okay? He said yesterday he was going to watch because he and his husband were talking about writing a will. They know they've got to write a will. So, and I know Jenny, I've messaged you, Jenny. Can you just have a quick look at that and tell me if that's okay? Because Jenny's got a very interesting situation. I just wanted to check it was okay to discuss that in a minute.
Yeah.
But she might not want to, but I don't know. Anyway, so sorry, there's a little bit of a pre-gabble in there. So Ruth, could you just tell us a little bit about you and your practice, please?
Yeah, of course. So, like you said, Claire, I trained as a solicitor and I worked as a private client solicitor for about 10 years in different firms around Kent. So in that time, I dealt with all sorts of clients from, just normal people like me with just maybe a couple of assets and no inheritance tax problem at all, to kind of super high net worth clients, loads of businesses and different properties and buy-to-lets and things like that, and foreign assets. So really, I've dealt with the whole spectrum of clients in relation to their wills and inheritance planning. But I set up my own business about 3 years ago just because I wanted to kind of take it back to basics, really. And for me, it's all about building relationships and building trust with people, and that's really important, I think, when you're talking about wills and legacy planning and things like powers of attorney as well, to do with ill health. Quite often my clients are elderly or a bit more vulnerable, and I really wanted to take the time to kind of speak with them and give them the time they needed. So that's why I set the business up. But
yeah, because it's tricky, isn't it? It's not a subject people want to talk about, and it's sensitive, and you have to weigh up how that individual is. I mean, I know from being a celebrant that I've spoken to some people and they're, oh yes, he was such and such and he was a right laugh, and they're happy to tell me stories. Other people are, they're not in a place where they really want to expand on it, and you have to get the information out very gently, very in a very dignified manner. Other people are falling over themselves to share their memories of this wonderful uncle, granddad or auntie, and other people it takes more time and a different set of skills. So first off, what is the importance of a will? Can you explain what a will is? I mean, I think we all know what a will is, but the actual what it is legally, I think that's the big thing for me to understand the legal point of a will and the legal standing of a will.
Yeah, okay, we'll take it right back to basics. A will is a formal legal document, so there are lots of formalities around it. It has to be done in a certain way. It has to be written and signed properly with 2 witnesses. So anything else that's like a wish that you leave that's not done with those formalities will not be considered to be a will under English law. And within that document, you're explaining who you want to look after your assets after you die, so your executors. If you've got children, you'd probably be appointing guardians to look after those children. and then you're deciding what happens to your estate, so who benefits, who inherits, who are the beneficiaries. In some cases there are also things we can do to help save inheritance tax and things like that. So, you know, basically it is a document that's going to be legally binding under English law that decides all of those things. And if you don't have one, then something called the intestacy rules will apply. And they're the set of English rules that decide what happens to your estate if you don't have a will, or, you know, if you've got something that you think is a will but doesn't have the 2 witnesses and things like that, and isn't legally binding, the intestacy rules would apply. So, you know, they're really rules that they're quite out of date. So they, for example, they don't recognise couples who aren't married as having any entitlement.
Oh, wow.
To estate. They don't recognise stepchildren as having any entitlement. So, you know, there's a bit of an argument that they need to be reviewed and modernised, but at the moment they are, you know, they are what they are, and they will apply in the absence of a will.
Because that's huge, isn't it? Because if you think about, so many people live together and aren't married. I mean, Mark and myself lived together for 3.5 years before we got married. And, you know, lots of families these days are first, second, third marriages or partners, and there are stepchildren, half children, you know, half siblings, and that's half children. It's not a half children, but, you know, there's half siblings, and they're, you know, blended families where people have come together, and you wouldn't want to miss somebody out, would you? And that's it. So it's a really important thing to do, isn't it?
And especially for those kind of more complex situations, you definitely would want to be seeking advice about a will, because, you know, if you're not married to your new partner, you would want to make some provision for them. If there are 2 kind of sets of children and it's a blended family, you might want to put some protection in for each of those sets of children, in case, you know, there are instances where, you know, people fall out after the first death and disinherit their step.
They do that.
Really, really important. You know, the more complex your kind of family situation is, probably the more need there is to have a will. And I always, you know, there's obviously the legal explanation of what a will is, but I kind of just taking it right down to basics, it's the only way you get to have a voice after you've died. So this is a situation where you're no longer around, you have no control. So the way that you have control is to have this legal document in place, which is you telling everyone what you want.
Yeah, and it's been your life, and it's your things, your house, your money, your personal possessions, and it's not just about the house and money, is it? It's about you know, if you've got jewelry that you want to pass on. For example, I wear my nan's engagement ring, which I wouldn't just want chucked in a box, and, you know, because it's, I mean, it's all, you know, it's, and I know my mum wears, or my mum has her mum's wedding and engagement ring, and those things, they're so precious and they're so personal, aren't they? So it's, you know, and after you've gone, you know, you need those things, your voice is still heard, isn't it? And I don't know if, I think you shared my post this morning about the number of people that die intestate, which is the term if you die without a will, or those people that without a will. And in my age bracket, which is 35 to 54, obviously nearer the 35 bracket.
That's my age bracket as well, Claire.
I'm nearer the top. I'm much nearer the top. But in that age bracket, it's 68% of people haven't written a will. And that is just, that's a huge amount. And something I learned from your live clinics, which we'll talk about later on, is that because I wrote my will before I remarried, that makes my will null and void, doesn't it?
Yeah, that's right. So if you write a will and then you get married after you've written your will, that marriage will revoke your will that you made previously, apart from in very limited circumstances where you've made your will in contemplation of marriage. So, you know, where you've got engaged, you make your will before you get married, you can put some wording in. But yeah, generally speaking, if you've got a will and then you subsequently get married, the marriage will revoke your will. And then, even though you think you've got a will, you could end up dying intestate. So those figures that you spoke about, Claire, will include people who've accidentally died
Yeah, and that's and their UK figures. I think they were 2017. But I mean my will needs rewriting, because in my will, the most important thing that I did that for was for my children at the time was small. And at 23 and 25, I don't think I need to worry too much about, sort of passing them on to my parents for looking after them. And my parents would probably be like, no, don't. They'd love it actually. But that was the main crux of mine when mine were little. And I know one of my friends watching, she's got 2 little girls who, obviously it's a concern for her, and they are little. They're 3 and 8, something like that. They are 4 and 8. They are very little. So for her, it's for people that have got young children, it is a huge concern, isn't it? Of who, that's a major thing. That would be my biggest concern, writing the will. So can you appoint people to look after your children?
Yes, so appointing guardians is one of the key reasons for doing a will. When I did mine, back when my children were a bit younger, that was the big issue for me, because like you say, I didn't have many assets. Actually, because my husband and I owned our house jointly, it would just have passed to each other. So it wasn't really for the assets, it was to get those guardians appointed for our children. So it's very straightforward. It's just a clause in the will where you just name the people you want to appoint. Obviously, it's a good idea to have a discussion with those people beforehand and make sure they're happy to look after the children.
That could be a bit of a shock, couldn't it?
Yeah. So yeah, I'd always recommend that. But and you might want to have a main guardian and then a backup guardian, just in case anything, your main guardian emigrates to Australia, you might want to have a backup.
I mean, it is a huge thing. I mean, mine would have been my parents, but for some people that's just not an option, so what, when you write a will, so do you want to talk us through what happens, what you need to know, because presumably if someone, because I know you have executors and I know roughly what they do, but if you can explain who you need for, I know you need executors and witnesses. Does somebody have to know they're an executor? If you could, I'm really sorry, I'm going to have to go and let the cat out. She's meowing and meowing. I'm really sorry, everyone. If you could, sorry.
So before you write a will, there's probably a whole kind of planning process that needs to happen, before you actually get that document drawn up. So that would include a consideration of the key people who are going to be involved. So as Claire has just said, executors are going to be really important. So they're the people who will deal with your estate after you die. So they do all the fairly boring but essential jobs, like applying for the grant of probate, which I can talk about in a minute, which is a document you get through the court to help you release the assets in the estate. They would pay for funeral bills and things like that. They would essentially collect all the money in and then distribute it to the right people. That's the main job of the executors. So you're going to want to appoint people who you really trust, who are good with paperwork and admin.
So people that you know quite well, not somebody you met yesterday.
I mean, some people have professional executors. So if your kids are still young and your parents are wouldn't want to have that responsibility, some people have an accountant or a solicitor doing it, but they would then charge fees. But yes, someone ideally, and they can be the same people as the beneficiary. So it's quite common to have like your husband as your executor and your beneficiary, or your husband and your children if they're over 18. An executor has to be over 18 to act. That they might inherit, and they could be the executor as well.
There's not a clash of interest there. That is okay.
Not, unless you're setting up a kind of certain trusts in your wills. Usually there's not an issue, because the job of the executors is to put everything that's in the will into effect. So they're bound to put what you've put in the will into effect. So they don't have any discretion. It's just a case of they're putting your wishes into effect. So that's why it's not usually a conflict of interest.
Okay. That's good to know. So obviously with a trust, that would be different, because you might have to make decisions on how that money was spent.
So then there might be an issue with conflict in that situation. But and there are certain duties that an executor has, so it's quite a responsible position. They have to, if there's money, they'd have to invest that in a sensible way, and because sometimes it takes months or even years to wind up an estate.
Does it?
It can do it, you know, if it's a straightforward estate it shouldn't, but I've had some go on for 5+ years, so yeah.
My goodness, that's a really long time, isn't it?
Yeah.
Yeah.
So the things you'd need to know are who those executors are going to be, their full names and addresses, and again, like with the guardians, just check they're happy to do that and take on that responsibility.
Yeah, because I suppose you could appoint somebody, and then if they haven't known that they're going to be an executor, do they have to carry that out?
No, there would be, so I normally recommend you have at least a couple of layers of executors. So your,
Right.
you know, your main person and then some backup people. If you're appointed as an executor, you don't have to act. You can renounce, is what it's called, where you sign a formal legal document to say you don't want to be involved in the estate, essentially. And then if you do that, the backup executors could step in. So there are certain rules. I mean, don't want to get into the boring details, but if you've started to act as an executor, it's more difficult to then stand aside at a later date. So once you've started, you kind of have to finish the job.
Yeah, that makes sense, because otherwise it'd get a bit confusing, wouldn't it?
Yeah. But you know, there are, you know, sometimes you're halfway through an estate and then the executor dies, and it's confusing. So yeah, having a couple of, so you know, like your husband or wife or partner as your main executor, and then, you know, people have siblings or parents or grown-up children as the next lot of executors who can step in.
Yeah, okay, so it is, there is that sort of contingency plans for.
Yeah, that I'd normally advise that you.
Yeah, that sounds sensible.
I can't remember what the initial question was, because
so it was about witnesses as well, obviously.
Witnesses, yeah. Okay, so your will has to be witnessed by 2 people. They have to be over 18 and they have to be able to see you signing the will. So there are issues if, you know, witnesses have visual impairments and things. So and really importantly, they can't be anyone mentioned in the will. So if you're leaving your estate or a gift to somebody, that person cannot be a witness. It will invalidate the gift to that person.
Oh right, it goes that far, does it? That supposing, I mean, I was leaving my £3 million house to my son.
Yeah.
And you know, he was one of my witnesses. That would mean
he wouldn't get that gift of the £3 million house. So I usually say, to be on the safe side, people who are completely independent from your family, so neighbours or friends, provided they're not mentioned in the will, work colleagues. It is a bit difficult at the moment with COVID, so this is one of the issues that we're having, is getting the witnesses, because obviously we're all stuck at home.
Yeah, how would we do that if we wanted to make a will now? And my friend Ricky was saying about him and his husband wanted to make theirs. How would you go about doing, you know, within your COVID bubble? How would that work?
Yeah, so I mean, some people are still going to work. So
yeah,
it can be done at a social distance. So lots of people are taking their wills to work, signing it. As long as the other 2 people can see it, they can be 2 meters away and behind perspex and all of that, and then it can be kind of passed around. So people are finding solutions. Before this latest lockdown, I was doing a lot of standing outside people's doorsteps and, you know, watching them, and then they go back and I go and collect the will. I mean, we have had, you know, in the last few months, it's been announced that witnessing of wills remotely is now legal during the pandemic, and that's been backdated to January 2020.
Gosh,
so effectively, you could have a Zoom call with the person, the testator, signing their will, and the 2 witnesses on the Zoom call. The will then has to be posted to one of the witnesses. You have another Zoom call and everyone watches that witness, so then it gets posted to the next witness, and there's another call, and it's all, you know, it should all be recorded. This hasn't been, as far as I know, tested through the courts yet, so I'm very reluctant, and it has been, you know, expressed to be a last resort. So if you get witnesses in person, socially distanced, that's going to be much preferable. But I've not done a remote witnessing of a will yet, because, as I say, it's not been tested through the courts.
I was just thinking that actually that is going to be it'll be interesting when that comes to fruition, when that somebody actually does do that, because I mean, I'll be interested to see how that does pan out.
Yeah, I think we're all sort of waiting for the first one to go through probate and see how it pans out.
Okay.
But you know, for an emergency situation, it's absolutely going to be better to do that and get the will sorted out in a safe and COVID secure way than not have the will at all. So yeah, we're kind of welcome to the news that this is now available, but yeah, we'll see how that pans out.
Excellent. Because obviously if you die without making a will, that you don't have the choice of where it goes, do you? So
no, as we just discussed, it would then be the intestacy rules, and that would decide who deals with your estate. So you wouldn't have appointed executors. It will be dependent on those rules as to who deals with the estate. And
definitely.
Guardians. So potentially it could be the family courts deciding where your children
and you don't need that on top of so why would so what else can you bequeath in your will? So bequeath is the term, isn't it, that you use when you say I want this to go to so and so. So as well as house, money, I thought about pets, because I inherited a cat.
Okay.
It wasn't actually in my great aunt's will, but after she died and my cousin sold the house, where he went, he couldn't take the cat. So this poor cat, who was quite ancient by then, had been used to living with a 70-something-year-old lady, and it had come from a rescue home. I thought, it can't go back there. I can't, because she loved this thing. So it came and lived with me and my other 2 cats and my then 2 small children, and was terrified, but I couldn't do that. But can you bequeath pets to people?
Yeah, so animals, pets would be property, like anything else that you can own. And obviously some pets are very valuable, certain pure breeds and things. So you can leave a legacy of your pets to a specific person.
Wow.
So you can do anything. I've seen and I've drafted trusts for pets. So where you leave your pet plus a trust fund to look after that pet. And so it can be as complex as that. Or what most people would tend to do is do a letter of wishes that sits with their will, which is less formal. It's not legally binding, but it's a note of what they want to happen. So we've got a cat as well that we've rescued, so I've not left a legacy of my cat to anyone, but we've spoken to relatives, and we've just put a note that this person should look after her, and if not, she'd go to Cats Protection, which is where she came from. Hopefully she wouldn't.
I know that's the thing, you wouldn't want to send them back. So so those sort of things, do they have to be, because obviously when you write your will, you might have Tom the cat, or you might not, so those sort of things, can they be added later? I know if you officially add it, if you officially change it, that's a codicil, isn't it?
Yeah, so if you
that needs to be legal.
Yeah, if you had a legacy of a specific pet, and then that pet died and there was a different pet, you might need to change the will, either by just amending the will you've got or doing a codicil. I would always try and draft it to kind of bear in mind future events. So I would normally say my cat Astrid, that's my cat, or any future animal that I may own at my death would go to my parents-in-law. So it would cover it, so then you don't have to keep changing the will. And if you do a letter of wishes, one of the really good things about that is it's really flexible. It's not legally binding, but you don't have to that doesn't have to be witnessed every time with 2 witnesses. That's much more informal.
Oh, okay.
Adapt it and just store it with your will.
So you can change that if you then you lose Tomcat and then you get Jerry the mouse, and if you get that, Ricky's just said that answers my questions about my tortoises. I will be leaving a trust fund. Tasha's here as well. Morning.
Well, funnily enough, my granddad has a tortoise, which was my mum's. Well, there were 2. My mum and her brother when they were in the 60s. And so when they were about 10 or something, they both got a tortoise, and the tortoises are still alive, Timmy and Totty, and living in Manchester. And I think my granddad does have a clause in his will about where the tortoises will go. So
my goodness.
I think he's found a farm or something that will take them.
Oh, because those tortoises are like 60 odd.
Yeah, but I think
they do go on for a long time, don't they?
They may well outlive my granddad. So
yeah, they can go on for a really long time. Oh,
and
well, that's
every spring. It's like, are they going to come out of the compost heap and still be alive? Because they go into hibernation in the compost heap. So.
Oh, bless them. It's so simple for them, isn't it? They don't have to think about all these things. So we talked about you know, how you need to make a will, why you need to make a will, and the importance of it. What about preparing yourself for example, dementia is increasingly common. The number of people are living longer, people are unfortunately getting dementia, and also people, Rick says they can live up to 130 tortoises.
Oh gosh, well, they might outlive me then.
Yeah. There you go, Ruth. You might be passing the tortoises on to your daughters at this rate.
Yeah.
So if you know you have got a condition, for example, motor neurones, and you know that there comes a point when you are not going to be able to articulate. I mean, this is going more from wills into future planning, but wishes that you might want to have carried out about a funeral, for example. So you said about writing a letter of wishes. I mean, it's off on a tangent from wills, but if you know you're going to be ill, can you request that you do have this as a funeral, that you don't have that as a funeral? And if people, how do you prepare for if people were to perhaps no longer be able to be of what is deemed sound mind, as long as they were in sound mind when they wrote the will, obviously it still stands, but if they change it and then they later or you know, diagnosed with dementia or some other illness that may affect you know, their ability to make that decision, how would you go with that? I asked that because obviously from my old work that's come up a few times. So
I would start this whole process of life and legacy planning, or whatever you want to call it, with just your own process. It doesn't have to be in any particular legal format of writing a plan, and that could include your will and inheritance. That could include you know, anything about how you'd like to be looked after in later life if you can't look after yourself.
Right.
You know, want to avoid going into residential care at all costs, you know, that kind of thing. Who would you want to come and look after you? Are there relatives who can? All of that, not in any particular legal format, in a notebook. You might have a meeting with your family. I've just spoken to my parents about this kind of thing and had a very in-depth discussion with them about the kind of care they would want to have. And you know, they're in their 60s, they're not going to need it, they don't have any diagnosed conditions, but just as a chat. Some people even have a party talking about life and legacies planning.
Yes, and, you know, I saw your friends, somebody you
funeral planning, and so that would be the starting point. And in terms of funerals, you know, obviously what would you want, what kind of funeral, what kind of service, what kind of readings, do you want a humanist service, what kind of who is there a particular celebrant you want, that kind of thing. So without even thinking about legal documents, that's where I would start. And from that you can then draw out the legal documents that are needed. So we've talked about wills. On the funeral side, wills can to some extent cover funeral wishes. So if
they can
gone through that process and decided, right, I want to be cremated, I want to have a humanist service, and I'd like Claire to be my celebrant, and I would like this song as leading. You can put all of that in your will in a bit that discusses funeral wishes. Something you might want to think about is taking a funeral plan, and that's something else that you could think about, and essentially that kind of fixes the cost of a funeral to today's prices, because it's, you know, expected that they're going to keep going up, so that might be part of it. And that also triggers that conversation about, because a part of a funeral plan would be putting your funeral wishes into place with that funeral director. And then on the sort of, if you've got an illness that's going to affect your decision making, the legal documents you're going to be thinking about for that are called lasting powers of attorney.
Right.
And they are completely separate from a will.
Yeah, of course.
You can do your will without doing your powers of attorney, and vice versa. And And they are documents where you can appoint people who you really, really trust to step into your shoes and look after you and make decisions for you if you have an illness, like you mentioned, dementia or a stroke or even an accident.
Yeah, of course.
And you become incapacitated. So yeah, as part of that whole planning journey, lasting powers of attorney are a really important thing to consider. There are two different kinds. So one of them purely covers your property and financial affairs.
Yeah.
So you can appoint people to access your bank accounts, make decisions about your property, make investments for you if you've got a business, to kind of deal with your business for you.
Yeah.
That's covered by the finance LPA. LPA is just a shortened way of saying lasting power of attorney. And then there's a health and welfare LPA as well, which is again a separate document. You might have different people who you name in that document, and they would be the people who would make decisions about medical treatment, where you live, who comes to visit you, that all of those kind of welfare.
The care side.
The care side. So
yeah.
And arguably, I think that's one of the most important documents you could ever put in place, because that covers life and death decisions about you whilst you're still here. So and yeah, so really that the whole point of doing those is it makes your family's life easier, because again, you've decided before anything's happened what you want to happen, and they're just then having to implement your wishes. So
yeah, and I know from going to people, when it's been sudden, people don't know what people want. They're you know, so that's sort of Ricky's just asked a question, would that hold up in law? And he put that up when we were talking about I think, correct me if I'm wrong, Ricky, but I think that was about the plans for a funeral. I mean, and I know if you've got families that don't agree on what to do with a funeral, I mean, it's who's down to next of kin makes that decision, as far as I'm aware. So I'll just wait for Ricky to answer me there. But that came up earlier on, so I'm pretty sure that was around funeral planning. But with with mental health, I mean, a friend of mine had a situation which is he said it was okay for me to talk about, that their mother died, and they had been various husbands through the years, and there's a variety of half siblings, step siblings, and they died a few years ago. The will was done. That the mum did have bipolar. Right. And then later on, after the money was all sorted out, and one sibling in particular had lived with the mother and put a lot of money into the house that they lived in, and the rest of the siblings, step half, all the rest of it, said, yeah, that's fine, you put your money in there, you know, that's fine, you pay for that, that's fine. Another will was found later on by a solicitor they'd never heard of, who came across mum in a graveyard and thought, hang on a minute, I didn't know she was dead.
Oh wow.
Yeah. And they've got this other will where she'd had a row with the sibling that lived with her, and had changed her mind, but the money in the house wasn't hers, it was this other sibling's, and of course it's all done and dusted, and now it's all up in the air. So how do you and that's a specific question, I know, and you're just going, I can't unpick that right now, but with mental health issues, what I'm getting at, is it best to, if you know you have got you've got bipolar, or you've got a personality disorder, or you to maybe get that written down somehow? How would you perhaps get around that?
Yeah, this whole issue is basically about
capacity, isn't it, as well?
So capacity obviously means whether you're able to make a decision or do something. There's a very specific meaning behind testamentary capacity, which is the capacity to write a will, and there's loads of case law around it. Basically, you need to be able to bring to mind all the people that you ought to be benefiting, so close family, spouses, and you need to be able to know who those people are, who are your close kin. Basically, you need to know the extent of your estate and what your estate comprises, you know, not to the nearest penny of everything that's in the bank,
but a rough idea.
I've got a house that's got a mortgage, and I've got a bank account and an ISA, you know,
you've got an idea, yeah, you've got
Yeah.
a pretty clear idea that you own a house here. Yeah,
Yeah.
you haven't suddenly forgotten about a house down in Devon that you forgot you owned.
Exactly.
Yeah.
So that's in essence testamentary. There are other things that come into play, like if you've had a poisoning of the affections, so something like bipolar, it sounds like that might have been one of the arguments, that certain conditions can cause what the legal case law calls a poisoning of the affections, where, you know, the person might be able to bring to mind all their assets and all the people in their family they ought to benefit, but they're irrationally, you know, poisoned against a particular child, and there's no real basis for it. So, you know, that might have been a basis for challenge. So whoever is drafting the will, the legal advisor should be having, you know, really detailed conversations.
It's scruples as well, isn't it?
Yeah.
I mean, for the record, this mum and this sibling had this row, and then it was done and dusted, and they lived together till mum passed away. So it was.
Yeah.
But it's interesting. So you can challenge a will, can't you?
It can be challenged on the basis that the person didn't have testamentary capacity at the time, either that they gave instructions or that they signed the will. Potentially there might be things like undue influence coming into it as well, if they felt, you know, if one of the other siblings have marched him off to the solicitor's office and said, mum doesn't like Dave anymore, write him out, that might be an issue about undue influence of the other child. So it can get very complicated, which you know, sometimes if there's a known condition, either dementia or you know, something like bipolar disorder, what a solicitor might do is get a doctor to give their opinion, and make a detailed assessment of that person and whether they have testamentary capacity. So there's an expert's opinion, but certainly if all these things are known about, any time someone wants to disinherit a child, the alarm bells kind of ring.
Yeah, of course.
Potential claim, and you would be very careful about making sure you're actually doing what that person wants, which at the end of the day, like I said, it's their voice after they die. You want to make sure that actually is what they want to happen.
Yeah, exactly. I mean, sorry to throw that in there, it just came to mind, and I thought, you know, it's a really extreme thing, but it does, you know, because I was going to ask you about if you change a will, or if you challenge a will. I mean, I've never been involved in a will being challenged, but you know, a friend has, so I just thought it was an interesting point to completely throw you with. Sorry.
No, that's okay. But it also brings up how important it is to know where your will is stored, because in that case, obviously there was a will that the family didn't know about.
Exactly.
So all sorts of things
only with the solicitor. Nobody else had clapped eyes on it, including former partners and everything else. So it is important. That's the other thing. If you write a will,
your executors and family that you've made a will or that you've made a new will, and tell them where it is. And also there is something called Certainty, which is an online national register of wills. So just be aware of that. The thing about it is you don't have to register a will with Certainty, so it's not complete, but it's always worth doing a check, just because it might throw up, you know, a will that nobody knew about, and it's just an online search the family can do for a small fee.
That's a really good idea. I'll just, Ricky's just said what his point was, but I was going to ask you about, excuse me, I was going to ask you about sort of digital things as we move forward, and you said yes, it was about the funerals. Mum wants a straight to cremation with no funeral or service, and his sibling doesn't agree. She's older than me, so that will make her next of kin. That's just something they're going to have to argue with, isn't it?
Yeah, if funeral wishes in a will are just wishes, so they're not legally binding. So even if someone put in the will or in a funeral plan or something that she wants direct cremation, that will be a wish rather than a bind, because, you know, like we've seen with things like COVID, someone might have said they want a funeral with 300 people, and that's just not possible.
No.
And generally speaking, the executor would be the person arranging the funeral. So if he's named as an executor and his sister isn't, he would be able to make that decision. But yeah.
So that would be down to the executor is the easiest answer to that, because obviously
But obviously better to try and agree it whilst everyone's still around is always the best answer to.
Right, okay.
Yeah,
hopefully that helps there.
Yeah.
Yeah, I mean, there's well, I knew we were going to get some odd questions. Ruth does do a legal clinic, which we'll tell you about before we go, so you can ask more specific questions there, and she can have some time to sort of get them. I say my friend's story I just thought was just something you couldn't make up. It's the plot of a film, isn't it? And it is rumbling on and rumbling on.
Oh, I know.
So
the probate, and that's why, because it's just
the probate, we touched on that earlier on. What just very quickly, because
we're running out of time, aren't we?
Yeah, and I know probate and it is another huge thing, and I know another friend struggled with probate. Getting the probate just took forever, and so can you just quickly explain what probate is, just so that people are aware?
I mean, we often use the term probate just to generally mean everything that happens after a death, which is technically the estate administration, but often the word probate kind of just gets used quite loosely just to describe everything that happens dealing with a person's estate after they've died. It does have a technical legal meaning, which is related to getting a grant of probate, and that when someone has a will, the executors may have to apply to the probate registry, which is a part of the family court service, to get this thing issued called a grant of probate, which is really just a document to confirm that the executors are legally entitled to deal with that person's estate. So it's like a rubber stamp, really, to say, yeah, okay, you are the people named in the will to deal with the estate. I always describe the grant of probate a bit like a magic key. It unlocks the door to all the assets. So the reason you need it is, especially if it's like a second death, it's not just going to spouse, you won't be able to sell the property or rent the property or access large amounts in bank accounts or shares or ISAs without that grant of probate, because that's a rubber stamp kind of certificate that says to the banks and to the land registry, right, you can go ahead and release to these people.
Yeah, it is about releasing the funds,
there are other things,
ownership and the passing on of those things.
There are certain other things that are triggered by the grant of probate. So, for example, we talked about claims against the estate before. Once the grant of probate is issued, it starts a clock running, a 6-month clock, during which claims can be brought. And if people don't get their act together and bring a claim in that time period, they're time barred from bringing a claim after that 6 months, apart from a few exceptions where they can. They say there's
obviously if there's a change of circumstances somewhere along the line,
if they're really ill or something like that, and they so it can be useful for that point, from that point of view as well. So some people don't need a grant of probate to get the assets, but they're worried there might be claims, so they'll get a grant of probate anyway to start that clock running, so the executors are protected after that 6-month period. So that's probably a whole other discussion of
that's definitely we might revisit that. So the last question I've got for you was, I've seen Ricky says that's probably going to be the answer, thanks very much.
Oh, good.
The last question I was going to ask was about the digital stuff. What's the legality? There's lots of things I've seen where you can store your, I mean, for example, Facebook now, I mean, they did a thing, they asked me if I died, which I will die, hopefully not for some time, was I happy for Mark to be able to access, you could nominate someone who could access your Facebook stuff. Now, the stuff I put on Facebook, that's fine, but for passwords, digital passwords and things, are there storage places for those? Because this is going to be a huge thing with everything.
This is a bit of a grey area, and you know, every social media platform and you know, things like Google as well has its own policy, and it's all down to its end user agreements and things like that. So, like you said, Facebook has now introduced a system where you can nominate someone who can memorialize your Facebook account and things like that, and there are similar things for Google. It's really important, especially with things like Bitcoin, which have a massive monetary value, and things. I'm trying to think of the names of the online accounts now, PayPal and things like that.
I was going to say, you've got PayPal and sort of, obviously banking's all done online, but that would come under your will, wouldn't it?
So
But
your digital assets will form part of your estate and will pass to the beneficiaries, you know, as along with the rest of the will. The issue is your executor going to know you've got a PayPal account with a £500 credit on it? So this is a bit of an emerging area.
Yes.
There are products out there called digital vaults and things like that, where you can, you know, securely, and I'm not an IT expert, so I don't know how secure they are.
That's one for my son, I think.
Yeah, upload your passwords and have a digital note of, you can store your will there digitally, and have a note of your passwords and key information for media sites and things like that. My practical advice to most of my clients is that you could keep even just a notebook or spreadsheet or something like that with a note of your key passwords, or even just a list of your assets. So if you have got a Bitcoin and you want someone to know where to find it, you can alert them to that. Or you know, more usually, you know, maybe it's a photo account, you know, a cloud account, and you.
Yeah, I was thinking of that sort of thing, and like, you know, digital, our digital memory and our, oh, excuse me, you know, all the things we're involved in that might be that you might want to keep. I mean, I have heard of people on their deathbeds, their finger being placed on the phone so that people can access, because everything, you know, because so like phones are, you know, thumbprint or fingerprint, you know, and people doing that so they can change it to theirs, so they can access numbers, because people don't have address books anymore. And I was just thinking about, you know, I'm sure nobody particularly wants to, for example, I blog, I mean, you can read that, but if my children wanted my blog or anything I'd written, done, computers, I know that's legacy rather than wills, and it's a bit random, but there must be things people are involved in that some you want people to know about and some you don't. So that will be something that perhaps we'll see an emergence of, do you think?
I think so, yeah, because I think our lives are moving more and more online and digitally. And obviously the big providers have started to recognise this with things like with Facebook, and you can memorialise an account. I listened to a really interesting programme the other day about computer games and people being memorialized in computer games.
Wow.
When they've had an account, and like this boy met his brother who died in a gaming world because you know, his character or avatar or whatever it is in that game had been kept going. I think his dad had done it, but yeah, so there's a kind of digital life and fingerprint after death these days. So I think it's going to be a really interesting emerging area. The legislation covering wills is from 1837. So
wow, so it's
we need quite a bit of update. Even just this whole remote witnessing of wills is kind of a major change. So I don't know if it's going to come from legislators or probably more from the big tech companies.
I mean, that's approaching 200 years old, isn't it? And that's got, some of it will have no bearing on life now. Well, thank you, Ruth. Thank you. And sorry for throwing a few curveballs at you there as they popped up. But I know you do a clinic. Is it once a month, isn't it?
Yeah, yes. So over on my Facebook, Isla Law Facebook page, we do a monthly legal advice clinic. So, you know, I know people have, you know, some people can't afford to get formal advice about wills and inheritance and things. So, and especially in lockdown, you know, it's sometimes difficult to access legal advice. So I try to just set up something where people can ask. It's all free. And I'm going to, I've also got a Facebook community, which I can put a link to.
Please.
If you don't want to go on a Facebook Live, you can just type in a Facebook community if you've got a question, and I'll try and answer it.
Yeah. Brilliant. Okay, well, thank you very much. That's been somebody said that, Jenny said I had to toddle off, but thank you both, really informative. So I know we've answered Ricky's question as well, so thanks ever so much, Ruth. Thank you for joining us, everybody. I hope you got a lot out of it. I know I have. My brain is full.
I'm going to have a lie down now.
And you're going to lie down in a darkened room. So thanks for joining us, and I will see you next week. Okay, so thanks a lot. Thank you, Ruth. Bye.